All right. Good afternoon, everybody. I'm going to go ahead and get started at 12:01. Welcome to our first CFBLA membership meeting of 2022. I'm very excited. As many of you know, I'll be serving as the president for 2022, and we're going to have a great year. I appreciate everyone's patience with us so far. We had to, unfortunately, cancel and reschedule our January presentation because of the Omicron virus. So this is our first meeting. I also want to congratulate the rest of the new board members and the officers for 2022. Frank Wolf, who's our vice president, Lauren Reynolds, who is our treasurer, and Camille Seabrith, who is our secretary. So welcome to today. Before we get started with our main presentation, I wanted to make a few announcements, and then I'm going to ask, I believe that Judge Robson wanted to make a few announcements. So as everyone should know by now, March 11th is going to be our State of the District with Chief Judge Delano. She will be hosting that by Zoom to both the CFBLA and the JBBA. That information, including the Zoom instructions, has been circulated, and I know it's available on our website as well. And also, please mark your calendars for our first in-person meeting, which we're planning for April 21st. It's going to be a great presentation. There's details for that meeting on our website, and they've also been circulated in our email blast. So we're really looking forward to seeing everybody in person for the first time this year, aside from Judge Ginneman's wonderful retirement event. Also, please, if you have not renewed your membership yet for 2022, please do so. You can reach out to Noreen Shaughnessy to do that, or you can go onto our website. And we've also posted our annual sponsorship levels for 2022 on our website. And I think the biggest perk out of all of them is going to be opportunities to sponsor the annual seminar. We're very excited about bringing back the annual seminar this year. It's been a few years since we've had it. And right now we're still trying to nail down a date, but we're looking at the second half of August right now. So please keep an eye out in your email and on the website for the save the date for the annual seminar this year. Let me just check my notes to see if there's any more announcements before I hand it over to Judge Robson to make some announcements. Right. So also, as you may have noticed already, you can't speak today. But if you want to, please, I welcome all questions for Judge Robson throughout this presentation. So if you have questions that come up during today, please put them in the chat, or you can hit the raise hand button if you want to speak, if we have time at the end for some Q&A. All right. Without further ado, I'd like to welcome Judge Robson, our newly invested judge in the Orlando division, with some announcements. Good afternoon, Judge Robson.
Good afternoon. Hi, everyone. Thank you so much for inviting me to speak today. I'm really enjoying getting to know all of you. Hopefully, I'll be able to meet all of you in person in the near future. Some of you I know I have met, but I do think it's important to participate in the, with the bar to make the practice, a better practice for all of us and our clients. So a couple of things before the Q&A session with Jonathan. First, I want to thank everyone on behalf of the court and Judge Ginneman for your sponsorship and participation in Judge Ginneman's portrait hanging ceremony and all of her retirement celebrations. I know she really appreciated that, and it will leave a positive lasting memory for her. Obviously, her portrait will be hanging on the 6th floor in the courtroom. I also want to remind everyone, Judge Vaughn's investiture, 2 years approximately after her initial swearing in, is coming up in Tampa, and that will be next Friday, the 25th at 4 p.m. Also, Judge Vaughn is accepting applications for a term law clerk. So this law clerk would start in September. So I believe I don't know if there's a posting on the website, but if there isn't and you know someone who wants to apply, I would encourage applicants to go ahead and apply for that position. Okay, the state of the filings. I probably don't have to tell you all that filings are down. As of the end of January 22, Orlando division is down 18% from the prior year, and district-wide, we are down 15% for the period of February 2021 through January 2022. However, despite that, we're still number 2 in the nation for filings. So we are one of the busiest courts and districts, in the country. So one other thing, which is a save the date. So there's a tentative date for my investiture, which will be June 21 of this year, 22. Fingers crossed. We reserve the ceremonial courtroom and the district court side of the courthouse, federal courthouse here, and the rest of the details to be determined. But it's the day before the Florida bar meeting starts, so we figured that might be a good time to have folks, available and able to participate in that. So those were all the announcements that I had. So I'm ready to go into the deep dive into the Q&A, Jonathan.
Great. Thank you so much, Judge Robson. And I also wanted to note for everybody, as everyone that went to Judge Gentleman's retirement event knows, it was a fantastic event. And it was our first in-person event and gathering of the year. And I think it went really well. And I look forward to seeing everybody in person this year. Again, we're going to start that in April, but hopefully there's no more Greek letter pandemic outbreaks that we have to deal with. But I appreciate everyone being patient with us and flexible. All right, so I thought, Judge Robson, we should start with some personal questions because this is getting to know your judge with the Honorable Grace Robson. And so what better way to get to know you than get to know you on a personal level. So first I wanted to ask you, you've been practicing down in South Florida for a couple decades. How has the move and transition been up to Orlando?
Well, I would say moving is never fun. So the physical move is not, the most fun, but I have to say that I have enjoyed meeting the people, everyone here from, whether it's the courthouse or even just in connection with, relocating and all of that has been great. My kids are in school here now, and that was also a refreshing change. And I'd say all the people are very nice, like both ways. So they're different. And you guys, the middle district does do things a little bit differently than the southern district. And some, so I'm not going to say that I'm abandoning the southern district as far as like the things that they do, but whatever I bring here, it would only be to help everybody and improve, the practice and make things better for everyone. So, so I would say it's a positive thing. I'm very happy to be here. It's been a nice change. So
great. Yeah. Have you had a chance to get out a little bit and try some of our local restaurants? We have quite a selection of restaurants in Orlando.
Well, that's one of my favorite things to do. I love to eat. So I have not gotten out as much as I want to, but I have a big list of places that I want to go. So the places that I have been that I've really enjoyed are, there's a place called Kabuki Sushi. It's on Colonial. I do like Prado, that's in Winter Park. I like Artisan's Table in downtown, and Cress, I think, is like a staple. But I'm also looking for some good Thai food. So if anyone has recommendations, please let me know, because I, in Fort Lauderdale, when I was there, I used to probably eat Thai food like twice a week. So if there's anything you guys would recommend, I'm happy to hear those recommendations.
I suspect for the next 5 to 10 minutes, we're going to get a lot of recommendations in the chat box.
All right.
We have a very good selection of Thai restaurants here in Orlando. And it sounds like you're already an Orlandoan because you've hit all the high points on restaurants. And you've identified Crest as a staple. So when you're not on the bench, what do you like to do? What do you enjoy doing?
Well, pre-pandemic, I did like to travel, and I tried to do that with my family a few times a year, not, work related, meaning for pleasure. And I'd like to do international travel. So that I haven't done since the pandemic, but that's what I'd like to get back to that as soon as possible. I also, as you know, as I just said, I like to eat. So tangentially, more recently, I've gotten into cooking and baking, which I think a lot of people have done during the pandemic. So those are things that I like to do. I do like to read books too, but because I've been focusing more on the job, I haven't read too much lately, although I am in the middle of something now. So.
All right. Well, I'm going to get back to those topics in a minute. But first, what do you think has been the biggest adjustment for you going from private practice to the bench?
The biggest adjustment is that I'm finding it's easier to get work done because there are a lot less emails and a lot less phone calls. I don't have to not really bill my time. I believe it or not, I do have to keep track of my time, but not like you practitioners have to keep track of your time. So that's a big adjustment, but in a good way. So I would say that's, one of the biggest adjustments.
Nice. So I think you've already talked a little bit about your family. You mentioned you have kids. Is there anything else you want to share about your family and your home life? Like, do you have any pets?
I have no pets. I did have a pet. He passed several years ago now, but I have been married for 24 years. It'll be 24 years this year. And I do have 2 boys that are teenagers in high school. So they eat a lot, or at least one of them eats a lot. And yeah, so it's fun. It's like, I feel like I'm taking a deposition every day when they come home, like, because they don't speak that much, they don't give me that information about what they're doing, what's going on. So I feel like I have to extract it. So
it's good to know that our lawyering skills can be an asset to us in our personal life as well, I guess, right?
Yes. And I feel like they've been the most difficult to get the answers. So I sympathize with all of the litigants.
They're very good practice.
Yes.
All right. Well, what book or books are you currently reading?
Well, I'm currently reading, I can show you. It's called Eats, Shoots, and Leaves by Lynn Truss. It's a punctuation book. So yes, I'm a nerd. But before that, I was reading fiction. So I was reading a book called The Vanishing Half by Britt Bennett. And then I started, but I wasn't able to finish. It was a book I had borrowed from the library, and then my time lapsed because I took too long to read it. But it was a book by Haruki Murakami called 1Q84. So it's kind of like a sci-fi type thing. So it was interesting, but like I said, it wasn't one of those like quick reads that you can just keep going. I had to keep going back to it. And like I said, the time ran out and the book was returned. So I will pick it up again at some point once I get a library card here.
Well, if you're anything like me, you're probably in the process of reading 10 different books at any one time. And I don't know how many books I've actually finished in the last 5 years, but I know I've started a lot.
Exactly.
So what's the last movie you watched?
Okay, you're not going to believe this, but The Godfather. So
nice.
I have never, in all my years, I have not seen the entire movie. I've seen bits and pieces, but I never sat from beginning to end. And so that was the most recent movie I watched. And but before that was Encanto by Disney. And I like all Disney Pixar movies. So
yeah, Disney Plus and Netflix are the only things we watch in my house. And if you liked The Godfather, you will love Goodfellas. So I recommend that next.
That I've seen.
Okay.
So I was thinking I'd make my way through the Godfather series eventually, but yeah.
Good.
Yeah.
All right. So I thought I'd throw a nice oddball question at you. It's a nice interview question. I'm sure we've all heard this if we've had interviews in our life, but what's the best piece of advice that you have ever received?
So I think this applies in many contexts, but I would say just to be yourself. So I think that's good advice, because when you're, let's say it's an interview situation for a job, you know, there's lots of things people will say, you should do this or you should do that. And maybe there are some things you should certainly be prepared, and you should certainly think about, you know, what it is that you're interviewing for and why you would want that job. This is, you know, just example. But I think overall, I think you should let your personality come through, as opposed to trying to be someone you think they want you to be. Because obviously there's a way to convey yourself that shows that you're competent, that you're prepared, that you want the job, and to do it in a way that is true to yourself. So I would say that's probably the best piece of advice.
That's excellent advice. All right. I have one final question for our personal round of questions. Out of all the places that you've traveled, where's the favorite place?
I would say Paris, because it is, there's a lot to do there. They speak a foreign language. I find that romantic. They have amazing food and history and art. And so, I mean, there are a lot of places that are very close to that, I would say. But if I had to pick like one place where is my favorite place and that I want to go back to, it's Paris. Awesome. Yeah.
All right. Well, hopefully you'll be able to go back to Paris someday soon.
I'm hoping. I was hoping to go this summer, but I don't know if that's happening either. So.
All right. Well, now let's move into kind of the more courtroom related questions. I know everyone's eager to hear about your take on the courtroom and how we as practitioners should conduct ourselves. So the first topic I wanted to ask you was, you know, an update on COVID-19 procedures and how the court is currently handling in-person proceedings, including requirements for obtaining an in-person hearing or trial, limitations on in-person attendees, and any accommodations that the court might have for witnesses or other interested parties.
Okay, so first I'd say for evidentiary hearings, I am scheduling them in person. Initially, I was doing them remotely because of the COVID and surge because of Omicron. So, but now I think anything that I'm setting now is an in-person hearing or trial. That being said, my order that sets the trial or any trial or evidentiary hearing will have a provision that says if someone needs an accommodation or wants an accommodation, just file a motion a week before, at least a week before the hearing, indicating why that accommodation is necessary or desired, and I will certainly consider that. So if, some people have different sensitivities, comfort levels and the like, and I will certainly accommodate that. It's we all need to feel safe in the courtroom. That's important to me. So I will accommodate people's needs on that aspect. So right now, like I say, and for regular hearings, as you know, there's always a Zoom setting during the pandemic anyway, but everyone is welcome to come in person anytime. And I have had some people come in over the past couple of months, and I enjoy seeing people in person, especially since I'm getting to know the bar here. So as long as you comply with Judge Corrigan's, order from July 30th, the COVID order with, the masking requirements and the physical distance requirements, anyone's welcome to come in at any time for any hearing. So I would say that that's, in place now, and I, welcome everyone to come in person. And I know Judge Vaughn does too. So besides those two things, as far as right now, there's no date that we've the court has determined whether, we would require people to come in, as opposed to, eliminating the Zoom component of it. So I think we're just going to continue to monitor CDC, and obviously whatever the district court does will be following as well. And then the other thing is, I guess, on emergencies, if you want to get my attention on that, you all probably are aware of that certificate of necessity, which is what brings the attention to a motion or emergency being filed to my chambers. And obviously, if you have not received a hearing notice or something like that, and you need something, then in that case, I would say also call my courtroom deputy. Oh, okay. So that, speaking of which, so my chamber staff. So my courtroom deputy.
Thanks for reminding me.
Yes.
I meant to start with that.
Okay. So I have the fortune of having an amazing staff. So my courtroom deputy is Gina Whitsett, which many of you probably already know because she was Judge Sheneman's courtroom deputy. So she's very familiar with all of the procedures and calendaring issues, and she's amazing at timing all of the matters so that you're not stuck in a hearing longer than you anticipated. So she has a good sense about that. Then I have two law clerks, Chelsea Moore, which I also snagged from Judge Sheneman, and Caitlin Meyerson, who's a new law clerk. She just started actually the 31st of January. So between all of them, I have a really good staff, and I would encourage you to, try to get to know them as well as best we can under these circumstances. But don't call chambers for, things that are not, appropriate. So with that being said.
Sure. Thank you for that. And we look forward to certainly meeting your staff in person as well throughout the year. And by the way, we already have a recommendation from Esther McKean on a Thai restaurant in the chat box. Thank you, Esther.
Good. Yes, thank you.
All right. Well, let's move on to discovery issues. Do you yet have any ideas for best practices or preferences for handling discovery disputes, including tips for avoiding and resolving disputes, as well as maybe when it's appropriate to contact the court to resolve disputes?
So what I would say is I would recommend, just like any other, or most other judges, nobody likes to have to hear a discovery dispute. So what I would say is I would recommend speaking with opposing counsel early on in the matter about the case and come up with an agreed discovery plan. I'm not saying that it's possible in every case. Some people are difficult, but I am finding that the practitioners here are very good about talking to each other and working things out in advance, because I've not seen too many disputes at all amongst attorneys, which is a good thing. So then I would say, in addition to speaking with your opposing counsel, tailor your discovery to narrow the issues. Think about, what evidence do you really need? What would be the best evidence, and tailor that to your discovery to obtaining that evidence. So for example, if you want to prove a debtor or somebody lied about something, you don't have to prove every lie that they've ever made in their lives. I think you can tailor your discovery to, let's say a few of the highlights, because if you only need to prove a lie happened once, you may not need 100 examples. Obviously I'm giving an extreme example, but that's, kind of the sense of it. Also, I would say stipulate to as many facts and documents as possible. That will minimize, fighting over, authenticity or, things that, like, even sometimes if you don't communicate with the opposing side, there may be a lot of facts that are not in dispute that you could stipulate to that will cut down the time needed to prepare and present. I have seen on one occasion where it seemed that two parties were saying the same thing, but they didn't think they were saying the same thing. So that can happen too. So I would say, obviously communicating with the other side, not just through emails, but actually picking up the phone and talking, because sometimes emails, as you probably all know better than me, don't communicate what you're trying to convey and may come across, a way not intended. So, and then if all these things don't work, and you've tried to resolve things and they can't, There is a local rule that, local rule 7001-14, that says if the parties are unable to resolve the dispute, you can request a telephone conference with the court to do, to issue like a preliminary ruling. So I, haven't seen that being invoked yet or requested, but if you've tried and could not resolve it, that's obviously available to you as well.
Excellent.
Yeah.
Have you had, did you want to say something else about that?
Well, I was going to say, so if,
Yeah.
and then if there's like discovery disputes about the scope of, or not, motions to compel discovery or things like that, there's a local rule for that as well. And that, just remember that if you're going to file a motion to compel, you have to address like each issue. So each interrogatory, each question in a deposition or request for admission or production, and then what your objection is, the grounds, for that, and also why any such objection should be overruled so that we can address that. So.
Excellent. I think I've only had one case where we've had to invoke the telephone hearing, preliminary hearing rule for a discovery dispute.
Yeah, let's keep that to minimum. So
yeah, I hope that is my one and only case.
And hopefully everyone is similar in that aspect. I mean, like I said, I've before coming here, I had heard that the practitioners are work very well with each other. And from what I've seen, they do as well. So I would say keep up the good work to all of you.
And I have to note that the opposing side was outside of our division.
Okay. Okay. Well, sometimes I find like state court practitioners, when I was practicing it was also difficult because they were more what I'll call litigious. I mean, obviously litigators are supposed to be litigious, but sometimes people fought over things that didn't need to be fought over, like continuances or extensions or, things like that.
All right. And I know you've already touched on emergency hearings. Obviously, everyone should be following the local rules. But do you have any suggestions for best practices for handling emergencies in your cases? Like, balancing different interests and obligations between clients and the court, whether or not something is truly an emergency, and then also like timing, and expectations for when parties would actually be able to get an emergency hearing.
Okay, so the first thing I would say is, think about when you're representing a client, I would say, make sure that they tell you, as much as possible about what's going on with their circumstances. And I know sometimes it's hard because if they are paying you by the hour, they don't necessarily, like getting those bills to say, oh, what I have to tell my, like everything that's going on, then he's going to send me a bill and, that. But I think it's important to convey that, there are certain things that require court approval. And, sometimes, if you want to avoid the emergencies, it's best to try to know what's going on in advance to kind of head it off at the pass. So sometimes you can't avoid it because it's just impossible. There's literally, but I think a true emergency is very rare. I mean, like, the house burning down kind of situation is very rare. But there are things that are urgent that do need attention, quickly sometimes. So for example, like a sale of a property where the closing date is, in short order, especially these days with people with lots of cash and the like. But I would say if your client wants to do that, make sure that they tell you about any contracts that they're, as soon as they can, obtain it so that you can give as much notice as possible of, for requesting a hearing. And to get our attention, obviously, like I said, it's the certificate of necessity that kind of triggers notice in chambers that something needs to be set right away. And if you don't hear soon enough, like I said, reach out to the courtroom deputy, our courtroom deputy, to get a time for that hearing. And we'll hear it as soon as possible. As soon as I'm available, we can hear it. And I try to balance the necessity of the hearing with giving some notice to opposing side and creditors. So I would say So for example, if a closing is going to take place in 2 weeks, I would probably try to hear it, closer to the end of the 2 weeks so that we can give as much notice as possible and still meet the needs of the client or the debtor in that scenario.
Your Honor, if we file a certificate of necessity, would it also be appropriate or inappropriate to follow that filing up with a phone call to Chambers right away, or should we wait a day or two?
Well, like I said, I think it depends on when you want the hearing or need the hearing. So if you filed something at 5 o'clock on a Friday, I can pretty much guarantee no one's going to see that until Monday. So I mean, so I would say try to also control that. So, or also things won't be said until you actually file it. So if you called and said, I'm going to file something, but it's not filed, we're not going to do anything with that. So I would say if you can, try to file it in business hours so that we can get it reviewed and scheduled for as soon as you may need it. So, and I would say it's okay to call the courtroom deputy if it's something that you really need set like within the week.
All right, thank you for that. What about continuances? Do you have any suggestions or tips or best practices for seeking a continuance? Keeping in mind all the things we've already discussed, like timing, the court's docket, client preferences and obligations, or your preferences.
Yeah, so right now I would say if it's an agreed continuance, for any continuance, I would say file a motion. So if it's agreed with the other side, then you can file it as an agreed motion. And I would say, put forth why you need the continuance and how much time you're looking for. So for example, if it's a matter that had been continued over a bunch of times, I may not want to continue it, but because unless there's a good reason stated in there. Obviously, if it's health reasons or something emergency came up, then I'm going to accommodate that. And I would think everyone here would do the same and consent to something like that. But if it's something that happens like last minute, like the day of a hearing, and you just someone from your office has to call, then I would say call. But just be mindful that my courtroom deputy is in the courtroom before the hearing starts to set up and stuff. So if you're calling to say someone can't make it or something like that the day of the hearing, it may not get to us. So, obviously file it in as much advance with advance notice as possible. But that being said, and try to get agreement. But if there's not an agreement, you can still file a motion to continue a matter or hearing. And just say that you tried to, get the other side's consent, and you couldn't get it. So, and then I'll consider that as well. As to extensions of time, which is kind of a continuance, but it's could be just a deadline to file a paper. Same kind of thing. If it's agreed, you can file a motion as agreed and submit a proposed order that would grant that and what the extension would be. And if it's not agreed, then I'll look at it on its own and see what the basis is for the extension. I have seen a few filings that were made after the deadlines. So for example, if it's a motion to extend time to file schedules and the rules say it's 14 days from the petition date and it's filed on the 16th day or something, and there's no excusable neglect cited in the motion, it just asks for a regular extension, then I'm not granting those. I'm denying those without prejudice to refiling to state what the reason was that it couldn't be filed timely. So it may seem a little harsh and I don't feel good about it, but I feel like I have no choice. So, I would say that.
So we should always read the rules, and especially those rules with respect to, what standard applies when you're filing a motion for extension before the deadline versus a motion for extension filed after the deadline, because those are two different standards.
Yes, it is. And like I said, you don't try to file it before. I mean, sometimes it does have things happen, but I would say if you're going to file it after, one, be aware of the deadlines, and then after, if it's after the deadline, you have to say why it wasn't filed before the deadline. So
thank you.
so that's helpful. Yeah, that's helpful to me, to help you. Help me help you.
I love it.
And like John, there is a local rule on continuances. It's local rule 5071-1, and it covers all different categories, and hearings on stay relief and, meetings of creditors, which obviously should be directed to the trustees and not the court. But
all right. Now we got a question in the chat box. Very exciting. Thank you, Tammy. I'm going to just read it.
Okay.
So there's an introduction and then a question. I'll start with the introduction.
Okay.
When filing a new Chapter 11, we don't know who to contact until the clerk's office assigns a judge to the case. The information we find online requires us to put which judge is assigned to the case. And I think maybe, I'm not really sure what context we would need to know the judge, but maybe it's a certificate of necessity for an emergency hearing, I assume.
Yeah.
And then lately, it's taking a couple of days for a case to be assigned to a judge. And so the question is there a person to contact at the clerk's office in order to expedite the assignment of a judge to a particular case? Great question.
That's a good question. I don't know who the person would be, so that's a question I can't answer. I should know the answer, but so what I would say is that we are aware that there was a glitch with the system. So technology can be a blessing and a curse with the case assignment. So yeah, that would be concerning, right? Because if you have first day hearings that you need set and you can't file that certificate of necessity until you know who the judge is. So I would say if something glitchy like that happens, then, call the clerk's office and let them know, like, we're waiting to do this until, a judge is assigned and, we really need an emergency hearing. So that's all I can offer. I can't give you the name of a specific person at the moment.
And I would assume that you would call the case manager assigned to the case based upon the case number. I think.
Yes, I think you can do that. I think there is on the court's website who the case managers are for cases ending in like the last 2 digits or something like that. So at a minimum, maybe you could, look for that.
All right. Thank you. That's a great question, Tammy. And we've now ferreted out some inside information on the court system. And I saw Judge Vaughn's comment as well. Thank you, Judge Vaughn. Okay. I'm going to go back to my agenda. Hearings and trials is the next section I wanted to ask you questions about. Do you have any best practices or tips or suggestions for preparing and submitting exhibits, case law, or other materials that you may want to review, including any preferences that you might have for timeline, format, and method of delivery of materials, or maybe you don't need anything delivered to you, like case law, for instance?
Okay, so I would say just comply with the local rule that 7001-1 on timing of when exhibits, unless it's superseded by an order that says exhibits need to be submitted by a certain date. I would say typically it's about a week before any evidentiary hearing. And as far as case law, I do like a table format. So you don't have to attach the actual cases, but if you want to give me citations for cases that you think are important, I would say, do it under a notice of filing, and, obviously connect it to whatever pleading is applicable, and try to do it with like the citation on one side, the name of the case, the citation, and then in the next column, like what the proposition is that you're citing it for that you want me to look at. And obviously, I would say only do these types of things with cases that you think are determinative, are important for me to know about, maybe if there's a split in the case law or something like that, but not necessarily for, like the summary judgment standard or things like that. So just something that's, you really want to get my attention is not just a standard case law for a type of procedural matter. And
Okay.
then if possible, for citations to case law, if you actually want me to read the cases, like I said, if you can submit it, at least a week before the hearing, so that I actually have time to pull the cases and read the cases and, look at them. Because sometimes, I know the local rule says file responsive pleadings and things maybe like 2 days before a hearing, depending on the timing of when it's set. But in reality, I probably won't be able to look at all of that and prepare for the hearing in a way that you would want me to, if I only have like 2 days before a hearing. So as much time as possible as you can give me, I would appreciate.
Excellent. And then what about presenting your case at the hearing? Do you have any best practices or preferences for lawyers effectively presenting their cases, including possibly narrowing issues in dispute, focusing arguments, effective use of materials, and then your expectations about communications between opposing counsel?
Well, I expect, based upon, the high regard all the judges have for the practitioners here, that they continue to work with each other on minimizing the disputes. And for presentation purposes, I think I like what I call like you're preparing for an appellate argument. I'm sure back in law school, you all had to do some kind of presentations where you say, okay, the issues before the court are X, Y, and Z. And the court should grant the request because of 1, 2, and 3. You know what I mean? So like Judge Williamson, I don't know if you all know, he has his general practice pointers that basically say, like 3 cases, 3 pages, 3 minutes, that kind of thing. And I wouldn't say like you should be bound by that per se or anything, but I do think that if you can focus your argument and really, sometimes it's harder to write less, than to write more. I don't necessarily need to see citations that are string cites. So like I said, I do agree with, your 2 best cases or 2 or 3 best cases, trying to simple statements of, what the facts are that are in dispute or not disputed. And then, what the best, like what statutes help you, what rules help you, and like the main case, a main, case law that might help you.
So I just reading another question from Walter Benanati in the chat. I'm going to go ahead and throw it out there.
Okay.
Thank you, Walter, for the question. I'll just go ahead and read his comment. Great to see you again. Our law firm is always neck and neck with Patrick Cordero down in Miami with number of bankruptcy filings. I believe it. I believe advertising is important because it educates a large segment of consumers what help is out there that they normally wouldn't have thought of considering. So Judge Robson, the question is what is your view of advertising in the bankruptcy realm? I don't know if you can handle that. It gets outside procedural questions into more substantive questions.
I mean, the law is also a business. So as long as you're within the Florida bar, regulations, and there are regulations guiding advertising for lawyers, I don't have a problem with it. I mean, like I said, it's a business. Everyone needs to market and make money. And so, as long as it's ethical and complies with all the rules, I have nothing to say about it other than that. So I'm all for filings. So we want more filings. So
Walter, whatever you could do to drive up bankruptcy filings, everyone is on board with. Okay, just be ethical about it.
I'm sure he is. So
yes, he is.
Okay.
All right. Thank you, Walter. Great question. Okay, well, before we move off of hearings, I did want to ask you specifically with respect to virtual appearances and virtual hearings, do you have any best practices or suggestions unique to appearing virtually?
I wouldn't say these are unique. I think they're pretty applicable across anything that you're doing virtually. So for a court, though, I would say, dress like you're physically in the courtroom. I think that does make a difference. If possible, I understand sometimes clients, debtors may not have the ability, but, dress to the best of your abilities. Try to be in a well-lit room if possible. It'll help, me see better. And then just the standard, test your equipment before the hearing starts to make sure that your sound and audio are working. Sometimes, because of the number of people on the line or whatever, there may be some technical issues, and, let's try to minimize that. I did have a hearing the other day where there were a number of folks, and one person had to basically turn their video off so that we could hear him, because there were too many, whatever was going on with the technology. I'm not a technology expert, but I just know that sometimes they say the word bandwidth and that affects it or something. So so just test, and just test for lighting, test for sound. And
I learned a bandwidth problem the hard way. Zoom was working perfectly on my laptop for a long time, and then I switched to a new account for a particular meeting. Luckily, it was a meeting, so important, but it wasn't a hearing, and my video wouldn't work. So many people on this already know about that.
right. And
it was a board.
Well, I mean,
it was our first board meeting for the year, so I was just a black screen. But
well, that's the thing with technology. It can be great, like, for hearings and meetings and things like that. But sometimes when you have issues like that, sometimes it's just like, oh well, if we just were in person, none of this, would have happened. So, so that being said, like I said, I think it is good for our clients, convenient for clients, certainly, who can just, log into Zoom and attend a hearing. But I do, like I said, I miss seeing people, in the courtroom. So.
Well, and speaking of, this is a good segue. I also want to thank Lauren Reynolds and the law firm of Winterweedle for actually hosting this virtual meeting. And just so you know, Judge Robson, we did get on 5 minutes ahead of time just to test out the IT on this one. So hopefully it's running smoothly for everybody. Okay, so let's see. All right, so we're actually coming up to the end, which the timing here is pretty perfect, but I wanted to ask you whether there was anything else that, any other suggestions or practice pointers that you have for the lawyers that we haven't already discussed or covered, especially maybe things that we should avoid doing in your courtroom. Anything like that?
Okay, well, okay, so first I would say everyone's doing a great job. Thank you for your patience with me. Obviously, I'm a new judge. I am adjusting to not only being a judge, but also in the Middle District, and so thank you for everyone being kind and accommodating. I would also say that I know it's kind of weird to kind of tell a judge, oh, I can't hear you or something on a hearing or something, but if you can't hear me on the screen, try to either let me know or let my courtroom deputy know so that we can try to address it before we're, going on and on at the hearing. And what if my audio isn't being recorded and no one can hear what I'm saying? And it's just, so anyway, don't feel awkward about that. I would just say, just let me know so we can make sure whatever needs to get recorded or transcribed gets done properly. And I think I probably said this earlier, but if possible, try to file responsive pleadings. So if you are, you have a motion that's filed and you're the respondent, I would say that it's not required that you file a response, but if there's a position you want me to consider or some case law that you think is applicable, that's determinative or something like that, I would say please try to file a response that sets forth, those either facts that are in dispute or case law that resolves the issue. and file that a week before if possible, or at least 2 days, depending on how close the timing is of when the hearing is set to, the motion being filed. And then on orders, so I don't know if you all know Judge Crystal in Southern District, but I have adopted his dislike for the word hereby. So if in orders, try to avoid here. I mean, I won't not enter an order that you guys submit that has it, but I wouldn't put it in an order that I draft myself. So that's just, one of my little personality traits or preferences. I also don't like the word instant. So if you say like the instant case or something like that, I don't, I feel that's an unnecessary word. So, and then the other thing on orders would be, nunc pro tunc. So I've gone away from using nunc pro tunc, and I would say you can use the phrase effective as of, fill in your date, because of the case law that we don't want to, run into. So we'll just avoid the issue. And then I would say as a practice pointer, rarely are there occasions where I guess chambers should be contacted other than those emergency situations that we talked about. You can call the case manager for issues regarding filing, or pleadings that are filed or orders that are submitted, or you can call my courtroom deputy, Gina, for calendar issues. And because my law clerks are really limited ethically on what they're allowed to say, so I don't want to put them in a uncomfortable position with trying to help, but they really can't say anything. So I would just say, if you don't get offended if you call my staff and they can't really tell you anything, it's just because they really can't. So hopefully this was helpful. I'm sure there's a lot more that we'll get to know each other over the coming years to come. And I hope that there's some in-person meeting that I can meet you all at.
Well, good timing, Mr. Kevin Zeus. We got a good question here. And also for everyone, if you have any questions for Judge Robson, now is the time to put them in the chat box. We have about 7 minutes left in our meeting today. So Kevin Zeus is asking, have you heard any news, it's a great question, on whether creditors meetings will be going back to in-person this year? My understanding is that we don't have any news on that, but Judge Robson, do you have any updates?
I don't have any updates. That is governed by the Office of the United States Trustee. So I'm sure that, I think emails have gone out in the past. I know that they would, that they're continuing to hold them remotely or by phone. So I would just say be on the lookout for that. I have not heard any update on whether they're going to change that anytime soon.
And we'll be going, as I've already said, we're going to go back into person on April, at our April 21st meeting. And I'll be reaching out to the U.S. Trustee's office prior to that to get announcements on items like that. It's a great question. So here's a good one from our one of our panel trustees, Lori Patton. The latest rule is on cases filed 60 days after the emergency order is lifted, but who, oh, sorry, it's a comment on the last question.
Well, I guess that's actually, if that's supposed to, be the time frame, everyone would just monitor, whether the emergency order is lifted. But again, like Ms. Patton said, who knows? Who knows when that
exactly? Who knows?
Fingers crossed, it's happens.
Who knows is the attitude we've been taking for the last 2 years. So we're all used to it.
Yeah, who would have thought we'd be going into a third year?
Yeah. No, we, as everyone probably may or may not know, we were hoping to have an in-person meeting too last month, and that those plans got soiled. So,
yes.
But I wanted to officially, we are looking forward to your investiture event, which will be in person, I believe.
Yes.
We are, I wish we could have had it already. I know you've been on the bench for a couple months now, but I wanted to officially welcome you to Orlando. And I think you'll really enjoy our community. and we're very excited to having you for the next 14 years,
Yeah.
at least.
Well, thank you very much. Like I said, everyone's been so nice, kind, and welcoming, and I'm really enjoying meeting everyone and seeing them in court or on Zoom, as the case may be, and getting to know the practice here. And I look forward to working with you all, in the years to come. So thank you for this chance to meet you all. Like I said, hopefully I will be able to meet you in person in the near future at some event, whatever that may be.
Yeah, and just a reminder to everybody, next month we are not having a regular membership meeting. There'll be the State of the District with Judge Delano, so look out for the Zoom instructions and make sure you register in advance. And then in April 21st, hopefully we'll all see each other in person.
Right.
So unless anyone has any final questions, I think this is a good time. We're ending a few minutes early. It's always good. And
Yeah.
I know we've already applied for 1 CLE credit for this meeting today. So just keep an eye out for that CLE number. And thanks everyone. And hopefully we'll see you all in April. Thank you again, Judge Robson.
All right. Thank you, everyone. Have a nice day.
All right.
All right. Take care.
Bye now.